Testing, testing.
You definitely weren't correct.
Testing, testing, 1, 2, 3.
Okay.
Now hit test again. Oh. Testing, testing, 1, 2, 3.
So it should be good then, correct?
It's not playing. Okay, wait. Testing, testing, 1, 2, 3. Now. All right, are you clicking it again? Testing, testing.
Yeah, it just says.
Okay, hold on. Let me come over. Here, O'Donnell.
Yeah. So I should be able to use.
Yeah. So you gotta click test until it says recording. Now click stop. There it went.
Okay.
Thank you.
I can probably turn up the volume.
You don't need to. That was just a really quiet thing we did.
Okay.
Good morning. Welcome to the Maryland Public Service Commission's administrative meeting for March the 8th, 2023. Good morning to Commissioner O'Donnell as well, who is joining us from an undisclosed location. Today is International Women's Day, and I'd just like to recognize all the very talented and professional women at this agency. My colleague, Commissioner Bubar, so many of the office directors that we have. I'm not going to name them all, but we are women-powered at this agency. I could not make it through my day without my very trusty advisor, Loretta Schofield, as well as all the other talented professional, administrative, and regulatory staff at this agency. So I'd just like to recognize the importance of today. Before we get started with the Commission's administrative meeting, I do have a few comments just reflecting on what is occurring in Annapolis. We have about 5 weeks left in the legislative session. A lot of bills that we're tracking this year. The Commission only sponsored 2 bills of its own, but focus on energy, environment, natural resources continues to be a priority for our legislators, a priority for this agency. I've seen a lot in my 22 years as a public utility regulator. The landscape has shifted dramatically. We've seen a changing energy fuel mix over the past 20 years, but we haven't seen a lot of change in this state, and I would say we are one of the most progressive states in the country. Natural gas usage actually increased year over year last year in 2022 versus 2021. That's just a fact. Global coal hit a new record last year in 2022. Obviously, in Maryland, we're weaning ourselves off. We have a few coal plants left, not too many. But in our efforts and attempts to decarbonize our state, we should also take pause to look at not only the national figures, but the international figures as well. My colleague, Commissioner O'Donnell, I think, had a great analogy last week of our need as a public utility regulator to balance. Balance is key. We need to balance the need for just and reasonable rates with the need for healthy public utilities in this state. And this is a complicated business. And having been in this business for 22 years, I recognize that it's not black and white. A lot of gray, and we try every day, the 156 regulators at this agency, to strike that balance. That is the burden and the responsibilities and the honor of serving the public interest. So it was terribly disappointing for me personally to see the editorial page of the Baltimore Sun criticizing this agency for not being sufficiently aggressive in pursuing energy efficiency goals, as well as regulating utilities. It's always easy to take a pot shot at any utility regulator stating that it's quote-unquote cozy with the utilities. I don't know what cozy means. I bet if you ask some of our utilities how cozy we are with them, I think you may get a chuckle or two. But the focus of the Sun piece was on energy efficiency issues, and the Sun, which is a trusted newspaper, got it wrong. The Commission's oversight of the Empower program has been stellar over the past 14 years. Empower has been recognized as a model for energy efficiency programs nationally. Over the past 14 years, we've averaged saving customers $1.50 for every dollar that is spent in the program. This has amounted to billions with a B, billions of dollars over the past 14 years. We've saved 14 million megawatt hours of electricity, and these are all verifiable facts. We do EM&V studies on Empower. Feels like every 6 months. We've avoided 10 million metric tons of greenhouse gas emissions, solely attributable to Empower. And particularly for the Baltimore Sun and its readership in the BGE service territory, customer usage has dropped over the years from an average of about 1,000 kWhs per month to about 850. That's meaningful. Baltimore Sun has not been participating in the future programming work group led by Chief Judge Chuck McLean over the past 2 years. I can tell you that. So it was disappointing to see that the Good Sun's editorial page got it wrong. What has the PSC and its staff been doing? Well, we've been working on grid modernization efforts, ranked third in the country behind California and Illinois in terms of pushing the envelope, innovating, doing what needs to be done, not only for energy efficiency that I just mentioned, but for the electrification of transportation. That's going to go a long way. Transportation emissions, tailpipe emissions, harmful exhausts, that's going to go a long way towards cleaning up the environment. In fact, just Friday, the Commission received a proposal from Baltimore Gas Electric for electric school buses. They attached a lot of letters of support to their application, and the Commission will turn to that application in due course. Although I'm hearing in Annapolis now, some groups are no longer supportive of the utilities being involved in EV charging, electrification. Others are supportive, so it's rather strange who the bedfellows are with the utility applications at any given moment. But we're a green agency. Over the past 5 years, we've done so much in terms of pushing forward not only the statutory mandates that we're required to push, but we've gone on our own in terms of initiatives. EV charging is just one. Solar, built out more solar in the past 5 years than probably the previous 100 years combined. Offshore wind. This commission has greenlighted 2 gigawatts, round 1 and round 2, and it sounds like there might be a third round of offshore wind coming our way. So we've done a lot there. Innovative rate making, we've been a leader there. Lots of options to better align the interest of customers and residential ratepayers, because as I stated at our last meeting, we've also assumed the mantle of being the residential ratepayer advocate. Distribution system planning has been key. It's crucial to making that a more transparent process to allow our citizens and our utilities to share information to achieve these policy goals. So DSP, the electrification study, what does a future with reduced natural gas infrastructure look like? We're working on that. DOE Chief of Staff congratulated this agency and its staff last month, noting that we're only the third commission in the country to have cybersecurity regulations on the books. Third. That's important. And of course, what I'm proud of, I tell the staff, I tell anybody who will listen, we are the most improved public utility regulator in the country. That speaks volume to the men and women who support this agency every day. We were the worst agency. We hit rock bottom in 2017. The regulatory environment was not kind. And we can't effectuate all these programs if we're rated the worst in the country. That has dollar impacts to our utilities, to our customers. Everything on the utilities balance sheet ultimately makes its way to the utility bills. So that's important. Proud of that. But that doesn't make a damn worth of difference if our utility rates aren't affordable. And I'm glad to see the Office of People's Counsel in attendance at our meeting today. Affordability is key. We keep loading up these bills, and I was listening to some of the testimony yesterday in Annapolis. Lots of bills. I was just tuning in and out. These bills were some of them are complicated. PSC opines on some and not others. Mr. Lapp was there. Mr. Lapp. Perhaps he's not paying attention. But what I was referencing was we have these bills with really, really expensive price tags. And we all know that utility bills are regressive, not progressive. So I agree with People's Counsel on that point. We'll need to look at. But then some of the testimony from witnesses, we had our People's Counsel testify yesterday on one bill that we should redirect the cost of these programs to taxpayers. Perhaps then the gentleman next to him, also in support of a bill, stated that, oh, well, these should be on ratepayers. When a senator questioned the witness, are these going to be borne by Maryland ratepayers or ratepayers of other states? The witness said, well, that's wishy-washy. That was the term, wishy-washy. Talking about billions of dollars. Can't be wishy-washy when it comes to that. No, sir. So, as I noted at the Senate budget hearing on Monday for the Public Service Commission, the chair gave me one opportunity to make any final remarks for my final appearance before that subcommittee. And I said, affordability. Don't lose sight of affordability as we pursue our quest to be the most progressive state in the country in terms of clean energy and clean environment, because that is a laudable and noble cause. But if consumers, residential ratepayers, businesses can't afford their utility bills, we got a problem. Last week I said I received 100 emails from upset residential ratepayers. Well, I now have about 150. But they stuck with me. So that's all I have to say about affordability. It's something that we should all keep in mind. This commission, Office of People's Counsel particularly, our legislators, our governor. And we don't have time to waste. I'd like to speak for a moment on retail supply issues. Retail supply issues continue to concern me. Last month I said we were on track to hit a new record in terms of complaints. We didn't hit the record, thank goodness. February is a short month with only 28 days. But it was another near record. We were only 4 complaints shy of hitting another all-time record. And as Commissioner O'Donnell so vividly described a few meetings ago, this is a shot across the bow. This industry needs to clean up, to get in line. And we're doing that. We're serious. We have our public proceedings underway, and we'll take those seriously. We'll process them efficiently using show cause proceedings and probable cause proceedings. In the past week, 2 of our offices have been busy issuing cease and desist letters. 8 or 9 of them went out. More to come. Staff, both in Consumer Affairs, Compliance and Enforcement, and Staff Counsel, have been on the job, like a patrol cop on his beat. Unfortunately, Office of People's Counsel yet again disclaimed any authority to be proactive and police this market. The People's Council issued a statement criticizing me, stating the chair apparently misunderstands OPC's authority. For example, he recently asserted publicly that OPC has cease and desist authority to direct retail suppliers to stop deceptive activities. OPC has no such authority. Oh boy. OPC has letterhead. I'm very familiar with the OPC statute. It's actually, one could be forgiven if not finding it in the blue book here, because it's only like 3 or 4 pages, maybe 5 pages long. Section 2204 gives OPC investigative authority, which to my knowledge they haven't used in terms of suppliers. As I noted previously, they haven't filed a complaint in 3 years against any retail supplier. They have supported the commission in a number of actions, and I do appreciate that. But being proactive requires cooperation with this agency, and I asked the Office of People's Counsel to commit to working with this agency in a cooperative manner. People's Counsel's position is that they're confined to just appearing before the commission as a party. Now, Office of People's Counsel has much a broader mission than that, notwithstanding the very brief statutory text. I'll give you an example. People love examples. 3 of us drive electric vehicles. My biggest pet peeve is when I see EVs parked. Not EVs, ICE vehicles, combustion engine vehicles, vehicles where you're powered by gasoline, to fuel the vehicle, and then they park in front of an EV charger blocking it. So the New Carrollton Public Library, and the chargers were blocked by cars, just parked. I saw a New Carrollton police officer. I said, shouldn't you ticket that car? And he's like, oh. He took a look. The sign said EV parking only. He looked in his manual and he said, I can't find. He was very diligent. He looked in his citation book. He's like, I cannot find where they violated city or town law. Handicap, yes. Curb, yellow zone, red zone. He said, sorry. He said, I am not empowered to issue a citation here. Fast forward, I'm at Whole Foods in Riverdale Park. Again, Whole Foods, rather progressive company, has free charging. Again, the chargers are blocked by iced vehicles. And I go up to the Riverdale Park police officer. And he said the same thing. He's like, these are Whole Foods EV signs. I'm not sure I can enforce it. And then he was like, you know what the heck? I could find something in the book. And he started writing tickets. I would ask that OPC be the Riverdale Park police officer, not the New Carrollton police officer. You do have that authority to issue cease and desist letters. And I will leave it at that for today. I turn to my colleagues if they have any opening statements. Seeing Commissioner Linton.
Thank you, Mr. Chairman, and good morning to everyone. I had a quick statement. I wanted to follow up on a comment that I made at our last administrative hearing when I encouraged everyone to be more present when it comes to the concerns I had about consumers reaching out for assistance after the lifting of the COVID-related protections, which of course will occur in a couple of weeks on April 1st or April 3rd, since that's a Monday. But this week, which would be my last time talking about this issue, I wanted to say something directly to the utility companies because I wanted to make 2 points. One, that as they already know, and I think I said this last week, I was not suggesting that there was any violation of statute or regulation that could occur starting April 1st when they are able to be more aggressive with collection action. Nobody suggested anything like that to me or suggested any misunderstanding. But I wanted to make that clear to everybody else, because I think the utility companies understand what I was saying, but I wanted to make sure everybody understood that as they begin their process of collecting on outstanding debts and everything, that is the normal practice. What we're dealing with now and what we've had to experience over the last 3 years was the abnormal period, when our utility companies did not carry out those actions, which are part of their tariff with customers and part of the Code of Maryland regulations and statute. But I also wanted to speak more directly to the utility companies and encourage them to reach out to our consumer advocates, our regulators here at the Commission, the different advocacy organizations that they know of, and to consumers that they know may need assistance. And the reason why is because our utility companies, all of you have the institutional knowledge. As I was thinking about it a little bit more over the course of the past week, we have a lot of very talented, but a lot of very new people in a number of positions where these issues are going to become important. Here at the Commission, at the People's Counsel's Office, at the Department of Human Resources, at OHEP, across a number of our assistance agencies, we have a lot of people who are very skilled, very talented, but they don't have access to that institutional background to know about what the world was like back then. Whereas the chairman noted last week, when you're getting hundreds of emails, that's what happens all the time. And so that's the world where we'll see in the next couple of weeks as the utility companies begin to ramp up again. And since the companies will have that institutional knowledge, they will know what types of complaints are pending, what types of customer numbers are out there, how many customers have expired turnoff notices, how many customers have outstanding arrears that need to be paid, how many are seeking payment plans today that everybody else doesn't know about. So I leave it to them to reach out to the organizations, to the individuals, to the offices that they used to have connections with in the past, years ago. And perhaps those connections have atrophied over the years because you just haven't had to use them. People have moved on. The COVID protections didn't require the types of connections and contacts that you used to have and maintain. This is the last couple of days we have left before those connections are going to become relevant and necessary on a daily basis. And it's very difficult to try and make them at a time when you really need them. So this is a time when you can take those steps today and all this week and all next week to reach out, to reestablish, reintroduce yourselves, let the community associations know if they have a customer who needs assistance, who they can contact at the utility company in order to get things moving to help that customer. The same thing works for the Commission, for the People's Council, for the state agencies, elected officials that are new, people who are not familiar with what the world normally looks like, but have only experienced it over the last 3 years or so. So again, it's not a criticism. I'm not accusing anybody of doing anything or not doing anything inappropriate. I'm simply suggesting that this is from a person who lived that time for over a decade and knows what that world is like, when instead of getting 1,000 or 2,000 complaints on an annual basis, you're getting that on a monthly basis. That's the world that is the normal world. And so at a time when we know inflation's higher, a number of other COVID-related financial assistance protections are expiring. We have a number of other financial challenges, some of which the chairman has alluded to this morning, that are on customers' energy bills. Interest rates are higher. With all of these other challenges that are out there, we know that there is a scenario building where there are customers that will have financial challenges paying their utility bills. And the utility companies, you already have this information, so you know what the eventual scenario will look like in May and June and July of this year. So I'm encouraging them to reach out and to take the actions that we've asked you to take, and as part of the order that we issued lifting the COVID protections. Encouraging you to take those actions and to make sure. Now, I'm not going to be verifying it, of course, but for various reasons. But I'm hopeful that they will do that, and in the future, a couple of months from now, I'll look in the newspapers and see nothing about this issue. And that's what I'm hoping will happen. So that's all I have. Thank you, Mr. Chair.
Thank you, Commissioner. April 1st will be here soon enough. Did I hear you, Commissioner O'Donnell?
Yes, Mr.
Oh, there we go.
Chairman,
Yeah, yes.
I did change my mind. If it's okay, I'd like to make just a few brief comments.
Please do.
I'm going to go back to a point that you alluded to today, and I had previously spoken to, and that regards arrearage management. As we go into economic times where, as Commissioner Linton was just saying, people have increased difficulty in meeting their obligations across the board for a large panoply of reasons economically. People have the misconception that somehow these arrearages, when people don't pay their bills, their electric bills, that somehow gets written off and goes into the netherworld. That's not how it works. The way it really works is it goes onto the backs of all the other ratepayers. Eventually, it will find its way onto the backs of the other ratepayers who are paying their bills. And that's the socialization that occurs in arrearage management. And during the height of the pandemic, we were tasked with getting some emergency help out the door to assist with arrearage management, and I think we did that effectively. But it's not in our normal wheelhouse in terms of social welfare programming, but we did it because we were asked to do it by the legislature. However, I would, and I agree strongly with the call for cooperation between the executive branch agencies, including the Office of People's Counsel and the PSC, and I would extend that, Mr. Chairman, to other executive branch agencies, such as the Office of Home Energy Programs and DHR, and the Department of Housing and Community Development Energy Programming offices, because they have large sums of money exactly for the purposes of forestalling arrearage management programs. And my experience, and this commission has heard it continuously in our oversight roles, is that it's difficult getting that money to the people who need it the most. It's very difficult. It's burdensome, and it doesn't get there. And if we could find a way for those agencies, look, as a sister agency in the executive branch, although we're independent, it's difficult for us to give management direction to another executive branch agency. We really can't do it. We can suggest some things that might help, but they're suggestions, they're not imperatives. So I would also ask that people understand we need help from the other agencies in the government and our friends in the legislature when they're doing the audit, when they're doing the reviews of the budgets of DHR, Office of Home Energy Programs, and DHCD energy programming offices, that they ask those tough questions. Why aren't you getting this money out the door? Why isn't it getting to the consumers who need it? Because that would go a long way in helping us alleviate what I see as an avalanche coming. And the more arrearage management we need to deal with, it's a situation that can spiral out of control, because you put more burden on people who are already struggling to pay their bills because of people who can't pay their bills. And then they fall into that category, and more people fall into that category. And pretty soon you got a big problem. So I just wanted to add that on to say arrearage management is real. It doesn't get written off in the tax code. It gets passed on and socialized to other ratepayers, and we need to be cognizant of that and get the money out the door that is kind of sitting there and not helping anybody right now. Thank you, Mr. Chairman.
Thank you. A timely reminder. Commissioner Bubar.
Thank you. Thank you, Chairman, for your remarks. And thank you for recognition of today being International Women's Day. And I also would like to basically express my just amazement and appreciation for all the women that work at the PSC. It's just been an awesome opportunity to get to know you all. Some appear before us regularly, not everybody, but it's just the talent and the skills of all the women that work here at the PSC is just really awesome. So thank you for recognizing that, Chairman. And I'm just going to reiterate some of the comments I made last week in terms of the responsibility, or at last AM, the responsibilities that we have as commissioners, and agree with the Chairman wholeheartedly that it's all about balance and finding the balance between all of the demands and expectations of our legislatures and the people that we work for, but making good decisions so that we try to maintain affordability. And it's hard. It's hard now. It's getting harder as we go into the future. And one thing I've noticed is, in addition to it just being something that my colleagues are referencing in terms of affordability and people who may have trouble paying their bills, there's more and more people understanding and recognizing what this is all translating into. I mean, just if you are on Nextdoor, people who are probably have affordable means, they're questioning, what is this Empower? I just saw I have $30 on my bill for Empower. What is that? They never knew that it was on there every month. And so they're questioning and asking, what is this all about? And so there's more and more attention being paid to this. And we have to be accountable for making good decisions and trying to find that balance. So as we go forward, whoever are the commissioners here, it's hard to make these decisions, but I have confidence that good decisions will continue to get made. Thank you, Chairman.
Thank you, Commissioner Bubar. Well, one thing that was neglected in the Baltimore Sun op-ed that I mentioned was the cost of the program. The commission was getting beat up. We're not going fast enough, far enough. Sun never mentioned the cost. Sun never mentioned who's going to pay the millions and billions of dollars here. We have meeting minutes to approve from our last meeting, March 1st, 2023. All in favor, please say aye.
Aye.
The meeting minutes are approved. Good morning, Mr. Secretary.
There are two items on today's consent agenda. Item number 1 is a request from Wave Energy Services LLC to cancel its natural gas supplier license. Item number 2 is a notice from Global Crossing Local Services, Inc. of the discontinuance of certain voice services.
Thank you. Seeing no questions, I would move that with respect to item number 1, that we approve the cancellation request, and with respect to item number 2, that we note the filing. The vote begins with Commissioner Bubar.
Aye.
Commissioner Linton.
Aye.
Commissioner O'Donnell.
Aye.
And Commissioner Richard.
Aye.
I vote aye. The two motions are approved. Mr. Secretary, the administrative agenda.
There is one filing on today's administrative agenda, item number 3. It concerns the transfer of ownership of Old Town Bridge LLC to Walter Fields.
Thank you. Good morning, Mr. Gregor.
Good morning, Mr. Chairman and Commissioners. James Greger on behalf of staff. This item concerns a request by Ms. Lori Roberts and Mr. Walter Fields, collectively the parties, for approval of a transaction that, once consummated, would result in the sale of O1C LLC to Mr. Walter Fields. O1C LLC is the operating company of the Old Town Toll Bridge, and the sale would involve the transfer of bridge facilities and franchise rights from Mrs. Roberts to Mr. Fields. The Old Town Toll Bridge is the only privately owned toll facility in the state of Maryland. It is located on the Potomac River between Old Town, Maryland and Green Spring, West Virginia, and is the only river crossing for approximately 15 miles in either direction. The toll bridge is subject to the regulation of the Commission by virtue of being defined as a public service company and common carrier under Public Utilities Article Section 1-101 E2 Romanet 6. PUA Section 5-202 states that without prior authorization of the Commission, a public service company may not assign, lease, or transfer a franchise or enter into any agreement or contract that materially affects a franchise. PUA Section 5-104A states that the Commission may authorize an act described in PUA Section 5-202 if it finds that authorization is consistent with the public convenience and necessity. In the instant filing, Ms. Roberts, the sole member and principal of O1C, proposes to sell all interest in O1C.
Mr. Gregor, can I stop you there for a moment?
Yes, Chairman.
The application of Mr. Walter Fields, was that filed under seal?
It was confidential, yes. It was the sale agreement.
Sale. Okay, so we won't be discussing that without the agreement of Mr. Fields?
That is correct, Mr. Chairman. If
Okay.
we dive into the specifics of the sale agreement, yes, that would be covered.
Thank you. We'll set that aside for now. I'd rather not go into closed session today. I noted that Office of People's Counsel filed what's noted as a confidential document. So, Mr. Greger, you know where the lines are, so please proceed. I apologize for the interruption.
No problem, Mr. Chairman. So in the instant filing, Ms. Roberts, the sole member and principal of O1C LLC, proposes to sell all interest in O1C to Mr. Fields. Mr. Fields would then become the sole member and principal of O1C. The transaction would effectively result in the transfer of the bridge and accompanying franchise rights to Mr. Fields through his ownership of the operating company. Mr. Fields is a resident of Green Spring, West Virginia, and works as an excavation contractor. He is currently primarily responsible for the maintenance of the Old Town Toll Bridge and has conducted the majority of repair work on the bridge since Ms. Roberts assumed ownership of it in 2010. Staff is confident that Mr. Fields has the technical expertise to manage the operations of the bridge. Additionally, it's important to note that on November 18th, 2021, case number 9672 was docketed as the formal complaint of Belinda Kaiser v. Historical Infrastructure Management, LLC, the Old Town Toll Bridge, and delegated to the Public Utility Law Judge Division. This complaint case concerned the physical condition of the bridge and whether the bridge operator had been adequately maintaining the bridge since the settlement agreement that resolved the bridge operator's last rate case in 2013. On December 22nd, 2022, the Public Utility Law Judge issued an order, Order Number 90482, that dismissed in part and sustained in part the complaint. While the record did not support a finding that the operator was negligent in its maintenance of the bridge, there were a number of outstanding repairs required under the 2013 settlement agreement that were left unfinished. A number of conditions were placed on the operator in Order Number 90482 for the purpose of compelling the operator to complete the outstanding repair work. The order became final on January 24th, 2023. Staff notes that the bridge operator in case number 9672 was O1C LLC, and the operator will remain O1C LLC after the close of the transaction at issue in the present application. The legal obligation to complete the work and satisfy the requirements of Order Number 90482 are not impacted by the sale of the operating company and its assets from Ms. Roberts to Mr. Fields. Mr. Fields himself did take part in case number 9672 as a witness for the respondent and is aware of the requirements of the order and the need for the bridge to comply with those requirements. Given the history, qualifications, and technical expertise of Mr. Fields and the operating company's continuing obligation to satisfy the conditions of Commission Order Number 90482, staff concludes that this transaction is consistent with the public convenience and necessity. Therefore, staff recommends that the Commission approve the transfer of ownership of Old Town Toll Bridge to Mr. Walter Fields. Thank you.
Thank you, Mr. Greger. Good morning, Ms. Eichner.
Good morning, Mr. Chairman, Commissioners. Mr. Chairman, I know you mentioned not wanting to go into closed session, but the specific concerns that we have do relate to the proposed sale agreement, so we feel that in order to discuss those, a closed session might be necessary.
I'd rather not go there. Let's hear from the applicants. Mr. Fields, is that you? Can you approach the podium to your right, please? And do you have an attorney with you? Okay. And do we have Miss Lori Roberts here? Okay, thank you. Mr. Fields, if you could just please state your name for the record.
Walter Fields.
Thank you. Mr. Fields, I'll ask you this question, and then I'll turn to Ms. Roberts. Do you have any concern or objection if the terms of this sales agreement is discussed in this public forum today?
I'm not sure how to answer that one.
Okay. Ms. Roberts, if you'd like to approach the microphone as well, please.
Because I am aware of the concerns for the Office People's Counsel, I feel that it would be agreeable to discuss those three concerns without violating any
So limited to those 3 terms of the sales agreement, you are comfortable with discussing in an open forum?
Correct.
Okay, thank you. Mr. Fields, do you concur with Ms. Roberts? Yeah, that's a yes on the record. Okay. We'll return to Ms. Zeichner, if the two of you could have a seat. Ms. Zeichner, let's just stay on those 3 items which the applicants have agreed to sharing publicly.
Thank you, Mr. Chairman. So OPC has reviewed the proposed sale agreement and has identified the need for 3 modifications or clarifications. I have discussed these 3 modifications or clarifications with Ms. Roberts and Mr. Fields. Since the filing of our letter, I was able to speak with Mr. Fields, and we all discussed this today.
Thank you. Ms. Eichner, did they have an opportunity to review your letter dated March 6th?
They told me that they did, yes.
Okay, thank you.
Thank you. And the Office of People's Counsel does not oppose the Commission's approval of this transfer if these 3 issues are resolved. And to describe these 3 issues further, first, there's a discrepancy in the name of the LLC referenced in numbered Section 1 and numbered Section 2 of the proposed sale agreement. The Historical Old Town Bridge Preservation LLC is missing from one of those 2 sections. So we just wouldn't want any confusion as to what entities are involved in this sale agreement.
So, Ms. Eichner, the official name is Historical Old Town Bridge Preservation LLC?
Yes, that is correct, Mr. Chairman.
Thank you.
And then secondly, the sale agreement should make clear that the purchase will transfer all shares of both LLCs to Mr. Fields if that is what is intended by the parties. The application references a transfer of all shares of both LLCs, but the sale agreement does not. So that is an inconsistency, and we feel that that could create confusion for the Commission and for enforcement later, if needed.
Thank you, Ms. Zeichner. It almost feels like you're operating in the capacity as their attorney.
And I'll clarify, I specifically put in writing and told both Ms. Roberts and Mr. Fields that I am operating in the interests of residential ratepayers and non-commercial users of the bridge. I told them that they may wish to get their own attorneys, but when I'm looking at this as a ratepayer advocate, and I want to make sure that the conditions of the Commission order regarding repair are enforced, I would be concerned if there are discrepancies in both the names and actually what is being sold. So that is my interest, and I think they would agree. I've made it very clear to them that I'm not providing them with legal advice, and I'm operating in the interest of residential ratepayers.
Thank you. I'll ask them that question in a minute to ensure that they did not believe that you were operating as their counsel, because you did provide some very good legal advice here, free legal advice to the applicants. One question before you proceed. I think we're halfway through number 2. Legal standing for OPC here. Obviously, it's a public service company. Who is the residential ratepayer? A private citizen driving their car over the bridge?
I would say yes, Mr. Chairman, and also private citizens driving over the bridge, because we were involved in the proceeding regarding the repair case 9672, based on the interests of residential ratepayers and non-commercial users of the bridge.
What's a non-commercial user?
I would say that is similar to, in this case, a residential ratepayer. But I think the interests are similar here for both commercial and non-commercial users. One would want to make sure that the bridge is adequately maintained and that the repair schedule is enforced.
I agree with you there. Well, I hate using the term residential ratepayer in this context here. And is that the statutory term in 2201, residential ratepayer, in your charge?
I don't have the statute in front of me, but that was our charge when we participated in case 9672, and that is our interest here as well.
If you'll just indulge me for a moment. Office of People's Counsel, 2204, under duties. Office of People's Counsel shall evaluate each matter pending before the Commission to determine if the interests of residential and non-commercial users are affected. Okay, Ms. Eichner, proceed.
And
Ms. Eichner, what in terms of rates, you are the ratepayer advocate, what is the rate of a vehicle crossing the bridge, the toll rate?
I unfortunately don't remember the exact rate now. We just went through that proceeding, but that was not a rate proceeding. So I don't remember standing here today the rates, because our focus at this point is that the repair schedule is enforced and completed as needed.
I can answer that question.
Well, Ms. Bell, Mr. Lapp, do you know the rates
People's Council. I do not, Your Honor, and I don't believe that issue is before the commission today on this agenda item, but we'd be happy to get back to you on that, or as staff has said that it does know the answer to that question.
OPC is the ratepayer advocate in this case. I recognize it's a sales agreement, but to be clear, OPC does not know the rate.
And Mr. Chairman, I knew the rate when I participated in the case, but I did not memorize it for today because it's not exactly relevant to this issue. But throughout 9672, that was brought up. I did review the rates, and no rate increase was proposed in that case.
Thank you, Ms. Eichner. I've never actually been to the bridge, have you?
No, I have not.
I saw a video on Google or YouTube this morning. Looks fun. We'll hear from Mr. Fields and Ms. Roberts in a moment. I interrupted you. I apologize. You were, I think, halfway through number 2.
Yes. So we just were concerned about that potential discrepancy in the sale agreement where it's unclear whether or not the shares of both LLCs are being transferred in the sale agreement, although that is referenced in the application. And then
If we could stop there. You're done with 2 now. If the commission is so inclined to agree with or memorialize item number 2, are you requiring the parties to go back and file a new agreement, or can we handle this on the bench today?
So I would recommend it. We did struggle with that. We understand that Ms. Roberts has visited from Florida for this proceeding. However, we do think that the commission should do a final review of the agreement, and we would like to do a final review of the agreement, because if the commission conditions its approval on 3 specific things, and then I guess who's to verify that those things have been addressed in the sale agreement? And I'm not doubting that Mr. Fields and Ms. Roberts could do that, but I do feel that there should be a final review once the sale agreement has been changed.
Mr. Chairman, with a recommendation, this can be handled through a compliance filing on the back end, so the commission can make a ruling today and then order compliance filing on the back end.
Okay. I'd rather not have Ms. Roberts fly. You said she flew in?
I understand she flew in from out of town. I don't know if she'll be out of town at the next meeting, but I do know that I don't want to create hardship either. We just feel that someone needs to look at it a final time before their approval.
Thank you. Let's move to item number 3, and then then we'll hear from the parties, and then we'll hear from the commissioners. I apologize again for the interruptions.
Thank you. Now, finally, of paramount concern for OPC is the fact that the sale agreement does not reference the legal obligations that both LLCs are currently subject to regarding repair of the bridge, maintenance of the bridge, a repair schedule, and the requirement to file a rate case if there are insufficient funds to complete the required repairs within a certain amount of time. So we have no reason to believe that Mr. Fields is not aware of these obligations. He was a witness in case number 9672. However, we would want any buyer to be fully aware of their obligations, and we want it to be clear that the sale of these LLCs or the sale of the shares of these LLCs will not affect the LLC's duty to comply with any commission obligations. So I, in fact, drafted some proposed language. I CC'd staff. I sent it to Ms. Roberts. Mr. Fields, I was told, does not have an email address, so I could not send that to him, but I know Ms. Roberts has it with her today. She pulled it out. And it's, of course, the commission can certainly suggest anything that it may wish, but our thought is that those items need to be covered in the sale agreement.
I appreciate OPC's zealous representation of the motorists who travel this toll road. How many residential ratepayers use this bridge on an average day?
Unfortunately, I don't know. That was also part of the case, but we were provided with payment logs, and I did review that, but that was a few months ago, and unfortunately, I don't know today.
I'm thoroughly confused as to how OPC picks and chooses its cases, but Ms. Zeichner, how do you respond to Mr. Greger basically saying the obligations he said, quoted, not impacted by the sale?
I would agree from a legal standpoint. If you're transferring an LLC, the LLC is bound by a legal obligation. I would normally agree with that. What concerned me upon reading this is that the assets are being transferred, but not the obligations. There's no commensurate language in the sale agreement that says that a transfer is occurring of both assets and duties, or assets and liabilities, or assets and obligations. That's what triggered the thought process for me. And that's why our office feels that this language should be included. And it's also an additional protection for the commission. No one would be able to say later that they weren't aware of these obligations.
Fair to say that position on number 3 is belts and suspenders?
It's pretty important for us, and yes, we feel like that it's a quick fix and it's pretty crucial.
It's important, but you stated that the terms currently, as reflected in the agreement, are legally sound. Is that what you said a moment ago?
I had concerns with that because the assets are being transferred, but there's no language referencing transfer of liabilities, debts, or obligations. So that's what concerned me. That's originally why we reviewed this and had some concerns.
Thank you, Ms. Eichner. We'll get back to you in a moment. We'll turn to Ms. Roberts and Mr. Fields. You could both come up if you'd like. I believe your interests are aligned. Is that correct?
Correct.
Okay. And just for the record, you don't have legal counsel present today.
No legal counsel present today.
Did you have assistance of counsel in drafting the application, the agreement?
No,
You drafted this yourself?
I did.
Okay, thank you. You heard Ms. Zeichner, and I'm speaking to both of you right now. You heard Ms. Zeichner's three concerns. The first one was the word historical apparently was, it's in some places, but it's missing in others. You agree that the official name of the LLC is Historical Old Town Bridge Preservation?
I agree.
Okay. Mr. Roberts, you agree?
Yes.
Okay. With respect to the second item she mentioned and detailed, any concern there?
No concern.
Mr. Roberts? None. Okay.
Mr. Fields.
Mr. Fields, I'm sorry. Ms. Roberts, Mr. Fields. The third item, it's a little more technical. Hopefully you've had a chance to speak to her. Concerns with what the Office of People's Counsel described as their concern.
I do understand the concern, and I'm with you. I think it's redundant. I think the law implies when you purchase shares of a corporation, you are purchasing obligations, assets, debts, liabilities, court orders in this case. We are all above board in understanding that that's what we're doing. Mr. Fields has been very involved with the complaint that was filed as a witness, a star witness, since he does the majority of the work. So I'm going to defer to the attorney who drafted the sales agreement to see the pros and cons of including that. If we must, if you guys order that it has to be included, I have no problem with it. I don't know if there is an objection I need to raise.
Thank you. No, I appreciate that. I suspect you're not an attorney, Ms.
I am
Roberts.
not.
Okay, thank you. You're both residents of West Virginia, is that right?
Yes.
Okay. Mr. Fields, do you agree with everything Ms. Roberts just
Yes,
stated?
I understand.
Okay. And you agree?
Yes.
You understand and agree? Okay, thank you. Mr. Gregor, would you like to respond to the three items Ms. Eichner detailed?
Only in the last point, Mr. Chairman. So what's being sold are the companies themselves, the interest in the companies. So the operating company and the preservation company that's actually holding the assets, those are being transferred to Mr. Fields. So the order specifies that it's O1C LLC that's the bridge operator, and O1C LLC will continue to be the operating company post-transaction. So there would be no impact on the requirements of that order as a result of this transaction because the operating company remains the same. The legal entity of O1C LLC remains unchanged in this. So that's staff's position as far as the legal obligation issue as far as complying with the requirements of the order.
Thank you, and I don't want to put words in Ms. Eichner's mouth, but I believe she effectively agrees with you on that point. Is that right, Ms. Eichner?
I tend to agree that that's what's happening here as long as we clarify that issue about shares because that actually is still up in the air. But I feel like this is a situation where an abundance of caution might be warranted.
Yeah, I don't know if I agree with you on that last point there. I'll turn to my colleagues. I'll start virtually if Commissioner O'Donnell has any questions for the parties.
Thank you, Mr. Chairman. I wanted to ask Mr. Fields briefly, and I don't remember seeing it in the workup for this admin item, or I could have missed it, but have you had previous ownership in either the operating company or the holding entity here? Have you had any previous ownership?
No, sir. No, sir.
Okay. I guess one of the things that kind of mystifies me, Mr. Chairman, over the years, I've seen this thing come before us several times, and it's always a change in ownership, or it seems to me to always be a change in ownership. At least that's my memory, which is known not to serve me well all the time. Um, but it seems to be a regular periodic change of ownership period. I'm just trying to figure that out, why that is. Ms. Roberts or Mr. Fields, do either of you have any commentary along those lines about my perception, or is my perception incorrect?
May I? Please. Your perception is correct, and it has been, I have noticed that, so I've operated the bridge and have been a steward of the bridge for 12 years. And I purchased the bridge off the previous gentleman who worked on the bridge for the prior owner to that. So it seems that the baton is handed from an administrator to a repair person, and then it piggybacks like that. So I think this is a natural progression that the person, the company that repairs the bridge, I purchased off Mr. Teeter, who used to work for Mrs. Walters, and he repaired it for her. So if you can see the pattern here, is this a lifelong pattern to sustain this bridge and keep it running? I don't know, but I think this is just the natural course of the bridge. It's ownership. Does that make sense?
Well, I will just say this, Mr. Chairman. This is an anomalous entity with regard to public utility companies, at least. I mean, it's under our purview, of course, but it's not something we see, and it's a bit of its own animal, if you will, in the regulatory space. I find it interesting. I don't have a concern as much as I understand the legal questions that were raised today, but in terms of the continuing function in the public interest, I don't have a concern. So I find it interesting that this thing seems to find a way to keep rolling somehow through changes in ownership, and I just find that interesting. Thank you.
Thank you. Yes, like you said, it's anomalous, our only private toll road in the state. And before I turn to Commissioner Bubar, the question on the table, Mr. Greger, the toll for a residential ratepayer.
$1.50, Mr. Chairman.
Thank you, sir. Commissioner Bubar.
Well, I have to say this has definitely piqued my curiosity, so I'm going to go on and cross this bridge. I don't ever remember seeing it, and it is an anomaly, so it's really interesting. I don't have any concerns either. I just have a question probably for Mr. Fields. Can you just talk a little bit about the remaining repairs that have to be done per the settlement agreement?
Yes, there's a pier that has to be refaced, and I was trying to get it done last year, but the river, if you do it when the river's down, it's a lot cheaper and a lot easier. So this fall, when the river gets back down, I was going to try to finish that pier up, and money's there and everything. It should be. So that's something else later on we'll talk about. But yes, I understand what needs to be done and everything. I've took care of the bridge for 12 years. Yes, since she's bought the bridge. Actually, I'm the one who talked her into buying the bridge.
Okay, interesting. And ongoing maintenance is manageable?
Yes, I take care of all the flood, clearing it and everything that has to be done. It is a low water bridge. Yes.
Okay. All right, thank you. I have no further questions.
Commissioner Richard.
Thank you, Mr. Chairman. And this is for Ms. Eigner for the Office of People's Counsel. No, I appreciate very much your involvement in this case and the time you've put into it. And of course, I know your plate is very full. So if you're here, this is something I think that we should all take very seriously and listen to your perspective. If I understand correctly, really the bottom line is you, the People's Counsel, would like to make sure that the terms are followed through, and that is the terms for repair of this bridge. So that's what we're trying to get to. Is that correct?
That's correct, Commissioner Richard. We feel that ambiguous language could cause issues in the future with enforcement, so we want the terms of the sale agreement to be clear so that the repairs are made appropriately and enforcement is possible if needed.
Okay. And it sounds like there's general agreement. I'm just listening, like you are, to the questions on number 1 and number 2, and then there was discussion of a compliance filing that I'm hoping will be entertained. If we were to get to that point at least, would that largely satisfy the Office of People's Counsel, or would it be your advice to commissioners that we reject this filing today, pending a number, getting number 3 completely spelled out?
I might recommend that a new draft is submitted, a new draft of the sale agreement is submitted, and then the approval could take place. Because if the approval takes place, I would guess there's very little that can be done at that point to change the terms of the sale agreement. So that might be my recommendation. I don't think individuals necessarily have to travel back. I understand they've traveled some distance, but perhaps the commission could ask for an amended sale agreement and then condition its approval on receiving that and approving that.
Okay, and would that be part of the agreement? I guess the compliance agreement, would that need to be spelled out, and would that also I guess negate the need for the parties to come back? I mean, could we act on that without again requiring redoing of this whole session today?
I think you could, and an OPC would certainly like the opportunity to review that and review one more time and weigh in. But yes, I think the commission, if it wishes, could probably ask that these 3 issues be addressed, or any issues that it chooses, that be filed, and then an approval can be made subsequent to that if those issues are addressed.
As part of the compliance agreement?
That's what
okay. Okay, well, I guess, Mr. Chairman, that would be my position, that, pending the, what we act on today complies with what Ms. Eichner just spelled out. I would be prepared to vote in favor of this, moving forward with this. Thank you.
Thank you. Commissioner Linton.
Thank you, Mr. Chairman. Good morning to everyone. A quick question for the technical staff, Mr. Greger. You've noted already in your filing, your Bucksheet filing, that the commission directed certain repair work to be done on the bridge. There was also a requirement that a filing be made for timing of those repairs. Where are we from a status perspective with regard to that?
So we've had discussions with the parties in regards to the timeline. That filing will actually be due April 24th. That would be the 90-day mark from the finalization of the order, which was on January 24th. So we've had discussions with the parties. They have a draft prepared for the timeline, and we're just working through some last-minute questions before that filing is made.
Okay. So are we talking about repairs that are going to require years to make, months to make, or are we...
I believe the major outstanding repair work is the Pier 6 repair work that Mr. Fields just discussed. So that is the only remaining major repair work to be done on the bridge that was a result of the 2013 settlement agreement.
Okay. All right. So some of my questions have to deal with the sale agreement, and I'm trying to think of the best ways to ask them without crossing any line. Looking at the language of the agreement, would it be your understanding that both the purchaser and the buyer acknowledge that the repair obligations exist and are covered within the agreement? I know that might sound kind of broad, but I'm doing that on purpose.
Well, it's staff's understanding that as the operating company is remaining the same, that it would be obligated to carry them out regardless. But through my conversations with both Ms. Roberts and Mr. Fields, they are under the understanding that yes, that Mr. Fields would be obligated to carry out the requirements of the order. I don't know if that answers your question.
It does. So, for the Office of People's Counsel, then I think it's fair. I think you would agree that between the purchaser and the buyer, under the terms of the direction that the commission has already given through the order, I know we don't have the timeline yet, but you would agree that between the purchaser and the buyer, one of them has the obligations, at least as of today, to make the repairs to the bridge.
That is correct, Commissioner Linton. I would agree.
Okay, so to the extent we are making certain that we'll assume then, since the agreement hasn't been completed, that those obligations have to fall to the purchaser, to the owner, or I guess it would be, yeah, I'm trying to make it easy without going too far into the agreement. So the owner, we'll just say owner of the bridge currently. As of today, the agreement hasn't been completed, hasn't been confirmed by the commission, so the owner has all the obligation. So it's just a matter of making sure that everything the owner has after the agreement is confirmed that now the buyer has.
I would agree with that, and I guess in a way that goes back to issue number 2, because it is unclear from the sale agreement whether the shares are actually being transferred. So then it gets very complicated. You have someone, I don't want to speak outside what I'm supposed to speak on, but I think issue number 2 might need to be resolved, maybe if for that to be the case, because it's not clear from the sale agreement if the shares are being transferred. The application references a transfer of shares of both LLCs, but the sale agreement makes no reference to that. So without that, I do worry about the commission's ability to enforce the terms of the order. It just becomes unclear who owns what, I would say.
Okay. I guess one other question, thank you. One other question for Ms. Fields. Once the bridge is sold, the party selling it, do you anticipate them having any involvement in maintaining the bridge and repairs of the bridge or anything of that sort?
Well, we're gonna keep in touch. I mean, she's gonna help me get through some of the stuff, getting it turned over to me and everything. Mm-hmm. And yes, I don't have no problem fixing the pier. That's what it's just coming down to. I mean, I agreed to it. I mean, right here in front of you, I'll fix the pier. I mean, I understand my obligation to fix it, and her obligation to have it fixed. So.
Okay. All right. Thank you.
Okay. Thank you, sir.
Thank you, Mr. Chairman. That's all I had.
Thank you.
Everybody.
Oh, any additional questions? Seeing none, thank you, Ms. Roberts and Mr. Fields. We recognize that this is a bit of a bureaucratic process. It's probably a little more difficult than the sale of a home in this case. I agree with People's Counsel that we should fix the typo in item number 1. Item number 2, Ms. Roberts and Mr. Fields acknowledge that the agreement for sale of business and the business assets are being transferred entirely. Item number 3, I disagree with the need to make clear where the obligations lie. The contract is clear in my read, staff counsel as well, that these obligations are not impacted by the sale. Ms. Zeichner conceded that it is legally sound and this is more belts and suspenders. I appreciate that, Ms. Zeichner. For these reasons, I would move that we approve the transfer of the ownership of the Old Town Toll Bridge to Mr. Walter Fields. I would also move that we adopt the recommendations as discussed by Ms. Zeichner as items number 1 and 2 in her March 6th, 2023 order to be addressed in a compliance filing at a future date, supervised by staff counsel. My motion does not include the third discussed item with respect to the obligations. The vote begins with Commissioner.
Yeah, Mr. Chairman, before we take a vote on that, can we just discuss it just a second? I would like to understand from the People's Council perspective, the motion that you've just heard. Does that largely cover the what People's Council would like to see how we act on this today to ensure that the bridge repairs are completed?
Yes, I think that that's consistent with what our thought process is. Of course, we would like to see condition 3, but we understand that the commission does not support that. So yes, I think that would address the issues, and as long as staff and the commission are able to review, and we would like to review the final sale agreement and make sure it is in fact compliant with the 2 conditions.
Okay, and does the motion provide that opportunity for OPC to review the review that you seek?
And I apologize, but maybe I could seek a little clarification. Would the condition, and if I may ask, would the sale be, I guess, would the commission's approval be conditioned on those edits to the sale agreement? Is that what?
Yes.
Okay, then yes. Thank
Okay, great. So you would advise an affirmative vote on this?
I think that is consistent, except for, of course, item 3. That assuages most of our concerns, yes.
Okay, thank you, Ms. Eichner. Thank you, Mr. Chairman.
Thank you both. The vote begins with Commissioner Bubar.
Thank you, and aye.
Commissioner Linton.
Aye.
Commissioner O'Donnell.
Aye.
And Commissioner Richard.
Aye.
I vote aye. The motion is approved. Today's meeting is adjourned.